Ombudsman, ladies and gentlemen, dear colleagues, I'm supposed to present you my conclusions. Now, there are two ways to do it. One, which I've heard so often, is colleagues who have written their conclusions long before the conference. I'm too lazy to do that, so I simply took notes during the conference, and therefore it will be a little bit a kind of a patchwork of conclusions, nothing very constructed, especially because this is a first step of a book which we intend to publish. We have already a kind of agreement with Edward Elgar, which is a very good British academic publisher, and then we will have a short session with the authors about deadlines. For the others, you should know that authors have a deadline tomorrow morning, but we are willing to extend it to tomorrow afternoon, and that's what we need to discuss with them. More seriously, it's just a few of considerations which I took note of, and conclusions are indicated for quite some time. We could go to 4 hours, like a speech of former President Castro, for instance, but I will try and keep it short, because what would be most useful is a little bit more time for a general debate as input for the authors and also for the editors, because Herwig and I will have this task. Just in order to place again this in the perspective, the project which we have been discussing already with Nikiforos Diamandouros a few years ago was to have something a little bit different from the 10th anniversary book, and to have something more academic, hence also more theoretical input. But we all agreed that it should be, as I said this morning, interdisciplinary, and you saw it, lawyers, but sociologists, economists, etc. And also something which I didn't mention this morning, but which is very important, we did not want to have the usual suspects. There are a few excellent authors who have been writing on the European Ombudsman a lot and a lot. Now, it's true that Roberto Mastroianni is the first Italian to have written on the European Ombudsman, but he's done a lot of other things than writing on the European Ombudsman. It's also true that Joana Mendes has written a few things, but she has a lot of other interests. So the idea was also not only interdisciplinary, but to have some kind of fresh look. And we knew that certainly with Joana and with Roberto, they would not simply restate what they had written earlier. Now, I will say nothing about the quality of what we heard, because I have a conflict of interest. As Herwig and I chose the speakers, I could only say it's excellent, but this would be modest, but I'm very happy. That's the only thing I can say. Now, just another element which might be useful for the discussion about conflicts of interest. I have a specific interest in research now in the framework of a research project financed by the Italian Ministry of Education, so they're not interested in contact, which is the issue of the protection of third parties. And for this, I'm extremely satisfied, because when I wrote the short abstract, which is in the program, that was long before, I mean, I think it was in September or something like this, and I'd hope it would come out, but it came out even more than I suppose, and I insist on this. So I think there's a lot to gain from this, and I hope we will have some discussion. Now, I see really 3 points which emerged in our discussion. First one, which is on the role and realm of the European Ombudsman. Roberto Mastroianni mentioned the Treaty of Lisbon. Also, Herwig spoke about one provision which Roberto, I think, did not mention, but which we know only too well, if I may say so, which is Article 298 on the open, transparent, and efficient European administration. I'll come back to the issue of what the European administration means, because apart from academic discussion, there are a lot of practical problems. What really emerged very clearly since this morning is this double role of a adjudicator. Mediateur is more easy for a Frenchman, because that's clear. That's why we called it Médiateur at that time. Now it's protecteur des droits. Nobody knows who protects what, but that's another story. Which is really the purpose, and I think it was very good to have Jacob Söderman reminding us of the debates at the time of the Maastricht Treaty. What I would find especially worthwhile underlining and maybe discussing again is the fact, which was stressed by many of you, but especially by the two ombudsmen, that the European Ombudsman can look at the follow-up. Courts cannot, with very few exceptions of very specific appeal mechanisms. But you can, and that's one of the elements which we found, which is linked to the other. Namely, one thing is a mediator who decides on single cases. The other, which is the one I'm most interested in, which is the own initiative reports, special reports. And the fact that I think Roberto did it again, mentioning the earlier reports, the one on access to documents. I think that's a fantastic example of how an initiative from the European Ombudsman, obviously not the only source, but is a quite clear source of a European regulation, and I would say even of the Treaty of Lisbon, the fact that it's now a fundamental right. Not saying that the European Ombudsman is the sole initiator, but this perspective of participation, maybe this was not underlined enough, participation of the European Ombudsman in standard setting, even at the highest primary law level. The fact that Jacob Söderman in the European Convention 2000 was the initiator of Article 41. Then with the help of some friends, they got it in. The fact that it was then taken again in the 2002-2003 Convention, I think it's worthwhile underlining. I don't know if I hope or I hope not that Emilio really will have to do the same job with coming treaty revisions, because as everybody, I think we don't know if it's we should wish for a treaty revision or not, and that does not depend upon us. Maybe David Cameron would have more impact on this, who knows. But what's important is this, to see that, and I think that's not only the European Ombudsman, but it's a specific feature which probably he has inherited from both the Swedish-Finnish model and from the Danish model, to have an impact which goes far beyond and in lawmaking. That's something which we have discussed a lot. I think that some of the cases which I've mentioned, we'll ask the authors to even insist more, and we might discuss again. Very typically, the questions of access to document have been a source for a lot of norms and practices, but also Frontex. It's interesting to see that the same Frontex is the source of not only ombudsprudence, but here in the sense of own initiative report, but also very interesting case law of the European Court of Justice. It's a pity that Alan Rosas is not here anymore. But there are interesting things coming. What I would wish is that indeed our authors go more deeply in trying to see what is the process, how successful complaints or unsuccessful complaints in certain cases have generated, on one side, proposals for reform, but also on the other side, without going into any kind of legal documents, a number of, I would say, changes in administration. what I was always struck talking with your predecessor is that Nikiforos always insisted on his, I would say, didactic role. That when he had to talk with the Commission or agencies, very often first having a kind of rather hostile or cold reaction. At a moment, a number of people found out that it was in their interest and that it could help. And here, without even going into the details of a complaint. What is also interesting, I would say, to go deeper into is what was said about a danger of successful complaints generating successful own initiative decisions generating more complaints. But I mean, that's part of the life. It reminds me of what we always hear when we are working on codification of administrative procedure. If you write it down, you'll have more complaints. Yeah, fine, all right. That's part of the rule of law, it seems to me. I hope we will have more on the relationship between the European Parliament Petitions Committee and the European Ombudsman, because this is something which I think on the academic side at least is really under-researched, if not unresearched at all. Lawyers are not interested in the Petitions Committee, they should, and they will, because there's a little bit of case law, but especially non-lawyers should. Now, this is a first set of elements where I think what emerged to me is mainly this, which was, in a sense, a prejudice of mine, but confirmed. The European Ombudsman, as it was maybe conceptualized, but mainly put on paper in the Maastricht Treaty, was here in order to solve individual problems of maladministration that we know. But happily enough, when writing down the Maastricht Treaty, the possibility of an own initiative was taken up. And I would be quite happy to know a little bit more if there were discussion on this, because those who were conscious of it obviously could only know that it would make a big difference. Courts cannot decide upon their own initiative, let alone decide without having to annul or something. Here, the possibility of own initiative has opened a way which has been used by the three ombudsmen, and which we witness it every day. Emilia O'Reilly is using a lot. And I think, to my view, this has an advantage, and we see it's more and more the link between individual complaints which you receive and own initiative. It was probably easier to see in access to document complaints than in others. But what we see here is that the European Ombudsman is, in a sense, a predecessor of something which we have in a number of agencies, that you have a procedural aspect, namely here the fact that you can have own initiative, which opens the way for the Ombudsman to be a protector not only of those who require its protection, but also for others. And I think that's extremely important. The Frontex case is the most obvious case. And we lawyers, when looking at these questions, I'll come back to administrative procedure soon, what we see is that there has been a tendency in the last 10, 20 years to reform national administrative law, administrative procedural law, mainly on the idea we should have a lean, quick decision-making process, which is very fine if you think it from the perspective of the complainant or the person who asks for something and the administration. But what we see is with many reforms, devils being in the details, the protection of the third party, I would say, in French we say les tiers, which avoids the word party. The one who is not even informed is important. I think that's very interesting. the treaty provision of own initiative, but also what you said about the structure of the Ombudsman's office. I think that's very interesting, and could be an example also for some other agencies which clearly have in their mandate to have a quite inclusive role, and which have problems because of the composition of their boards, or because the procedures they are creating are mainly directed at addressing complaints. So that's a line which, as I said, I'm personally very interested in, which emerged very clearly today. The second point was about output. Output of what the Ombudsman is doing, and it was not astonishing to have re-emerging several times what is the nature of reports or letters by the Ombudsman as compared to court decisions. It was stressed, I think it was by Alain Roses quite logically, but the people in the Ombudsman's office know it very well. There's probably quite a lot of difference between the General Court, let alone the Civil Service Tribunal, and the European Court, the Court of Justice of the European Union. Because the General Court is dealing a lot with what you are dealing with, and somebody underlined it, the fact that they are dealing with facts is much closer to what you are doing. The Court of Justice is a little bit in the background. We'll see if the reform of the Court of Justice goes along or not. I don't think that this will change anything for the European Ombudsman. Maybe it might change something that you would get even more complaints from officials or agents of the EU. What I did not hear very much, but I think we all have present, is that there's a time sequence. It is very well possible that something appears as a kind of norm of ombudsprudence, which then is taken up by the legislator, we know it, or by institutions, or by the court. The court is not always enthusiastic about it, but that's quite normal. But I think if we look at it on the long term, here we have 20 years. But already on 20 years, it would be interesting, I don't know if any of the authors will do it, to try and see what was something which was just a recommendation by the Ombudsman on how to behave 15 years ago, and now is hard law. I remember having had often discussion with Nikiforos in the years leading to the Lisbon Treaty, where he said, well, it's all very well, but if the Charter becomes binding, what will be my role? It was obviously his way to provoke reactions by a lawyer, and the answer was always, well, it's about maybe fairness, but if you look at it, there's a lot of case law of fairness. What remains very important is what we have said today. One, the Ombudsman does not annul an act. Two, it does not allocate damages. It can only recommend to the institutions to behave in a certain way. But apart from this, there's quite a lot of I would say, interaction in reality, directly or indirectly, between the Ombudsman and the courts. The Court of Auditors, I'm not saying it only because Alex Brenningmeier is here, but certainly here is also a body whose activity is under-researched by lawyers, let alone by people who should be specialized in public finance, although it's extremely interesting, especially because here we have something which I'll come back later, where we have a real interaction between the European Court of Auditors and the National Court of Auditors, which goes probably much further than what we know with courts and with the Ombudsman. Just one point about the nature of ombudsprudence. There are some cases which show this evolution over time. Thinking of courtesy. Think about courtesy. If you mention that the European Ombudsman says one of the principles of good administration is courtesy, usually when I say it in an audience of colleagues, they smile. And I'm very shocked when I do it with French, or why not? Italians are rather courteous, but with French colleagues, and we are discussing about immigration. I don't know if in Frontex that would be a thing, but certainly courtesy with immigrants is something which will probably generate far more than we had until now. Another element is the link between binding rules and internal proceedings. I found a very interesting statement of Advocate General Cocotte in a case Solvay, where she was saying that it's a case, probably a number of you know, where the Commission had lost the documents. We'll never know if they have lost it or something else. But where Advocate General Cocotte said, well, the mere fact that Solvay, the complainant, had not even an index of the documents constituting the file is a case of maladministration. There's a duty for administrations to have well-organized files, including indexes, etc. So where you see that's a case, but it's getting to where the European Ombudsman is trying to get since a lot of time. But apart from solving an individual issue, there are duties for the administration which are part of the standards for good administration. Now, I will not tell you something about the project of a code of regulation on administrative procedure. If people are interested, some of us are working on this since years. But the only point which I will mention is that here we have a very clear line. It all started with the European Ombudsman having its own proposal of a code of administrative behavior. Later on, the European Parliament adopting a resolution in between the Convention 2002-2003, putting something in Article 298 on which the institutions do not have the same idea, but we will see if it comes out. The only thing which I want to say on this is that in this relation, 2 years ago, I did a little bit of a study for the European Parliament, and I was astonished to what extent there were gaps on one side in existing hard law rules, EU secondary laws, compared to the European Ombudsman, or if it was not gaps, differences in formulation, where the Code of Good Administrative Behavior, because it was conceived not as a routine legally binding document, but as something to be used by first officials, but also, I suppose, the public, showed that there's very much room of progress. But I was also struck by the fact that there were so many differences between the Code of Good Administrative Behavior, which has been adopted by the Parliament, as we know, and those different codes of the European institutions, let alone the fact that I've not checked now, but 2 years ago, the Commission's Code of Administrative Conduct had not yet been translated into the languages of the states which accessed in 2004, which is saying something about how it is being used. Well, they will say it's normal because all officials know English, French, and a few. But I think that's saying something. On the reactions of the Commission on this, my favorite quote is, that's another to the Dutch, Willem de Mute, who said, "Il n'est pas nécessaire d'espérer pour entreprendre, ni de réussir pour persévérer." But I think that's very important. The different recommendations, letters, etc., of the European Ombudsman, in time, certainly have this effect, insisting, yet again, it's not yet solved. It's something which I hope my Italian colleagues will not be furious at me. My wife told me, if you deal with the Italian administration, you've got to learn something. You must become their nightmare. You must call them every day to say, where is my file? In a sense, can do it in a little bit more polite way, but recording that it's not solved is certainly one of the things which we did not mention, but I think the European Ombudsman knows, insisting again, and that might be the case, for instance, for the European Citizens Initiative. Now, the last issue is the more complex one, which I did not expect, but which we cannot avoid discussing. Now, the realm of the European Ombudsman is clear. Only institutions, bodies, offices, and agencies. But first, as Jakob Söderman recalled us, the initial project by the Spaniards was, and it's quite logical, in 1990, the Spaniards, Defensor del Pueblo, who would also deal with member states. Now, it's obvious that if we come up now with the idea the European Ombudsman should also deal with member states, you will have a few reactions, like, for instance, the Constitutional Court of a member state, which will decide that they are the ones who control the European Ombudsman. But on a more serious tone, we have to look at it because, well, Herwig Hoffmann said Article 298 TFEU speaks of a European administration. Nobody knows what a European administration is because the word European administration was not there before the Lisbon Treaty, before the Convention 2003-2004. If I'm talking with the Council, with the Commission, legal experts, they will quite logically say European administration. It's just because it replaced the former provision of the Fusion Treaty of 65 and the Amsterdam Treaty, which was speaking of a common administration. But it's not a common, it's a European administration. But that's a story for lawyers, and we will probably spend much time. More important is what was stressed by many of you, and namely the fact that we have, and we know it quite well, a system where the legal system is based upon a model, two levels, like Jarle was presenting in his model. And where the only exceptions, well, no, the only real exception institutionally is the preliminary ruling, which enables a correspondence, but Herwig insisted only vertical from the lower court, from the national courts to the European Court, not vice versa. For the rest, we have a system which we cannot change, and I suppose it will not be changed. That's certainly not what David Cameron would like to change, where certainly there is no way, formal way to correspond. What I've been struck for 20 years, 30 years now, working with national administrations, that they are desperately looking for something which we cannot provide them, namely a substitute of a request for preliminary ruling with European institutions. When they are confronted with a regulation especially, but even sometimes with a directive, they want to have an authentic interpretation. So what do? They ask it to the Commission. If they've got good lawyers, the lawyers will say, yes, ask the Commission, but mind you, the Commission doesn't have the last word. Now, this is a big problem for the composite administration which we have. The European Ombudsman has done what he and now she can do through the network of ombudsmen, but it's not yet enough, because happily enough for the ombudsman, as it's very informal, it has no boundaries, but it remains limited. Roberto Mastroianni recalled it that there's no Italian ombudsman. There's no German federal ombudsman, and as far as I know, there are only, 4 out of 16 Länder ombudsmen who anyway are not so... So I'm not saying Germany would need one, but if you want to have a very effective system of network of ombudsmen, having some correspondence is needed. What we know is that there's no legal basis at present to impose the creation of an ombudsman in all member states. At best, one could go to the necessity of having an authority for access to documents, but even here, The only point which we have is the data protection. And that was probably one of the most missing actors here. We didn't speak very much about the European Data Protection Supervisor. But what always struck me is the way both interacted in the Bavarian lager, certainly, but have to interact now. And I hope that in our chapters there will be something more. What I was struck, I learned something which I didn't know, namely that, and it's my fault, it just shows my laziness, that the petitions committees were members of the network. And that's very important because obviously I'm coming from a country where, well, we were very good at petitions before 1789. That's how the French Revolution started. But nowadays, I don't think that it's a very efficient way to do things. That's why we have a protector on the door. But it's something which is here, I'm quite sure, under-researched. In Germany, petitions committees, I think, are more important. But what importance do they have according to the lender? And so on and so forth. So I hope also that we will learn a little bit more about it. Last but not least, I think that what the Tredimas brethren, and especially what George told us, is very important. Legally speaking, the differences between member states should not matter. For something like the network, but also for the type of complaints, it has a lot of impact. So these were my rather banal conclusions. I only tried to put on the floor a few things which I hope will be taken up in a discussion if we have time, and certainly in the book. Thank you very much for your attention.
So are there, in a final discussion round, comments or observations? Thank you. Alex Brinkmeyer.
Well, after these beautiful words, I only can be very modest. But before I come to my substantive issue, I would like to compliment the organization for this excellent colloquium, because I think it's very fruitful, and it's really a pleasure attending it. And Jacques Ziller summarized the whole thing, and he brought many things to the discussion, and I think it's very hard to reflect on it. But there's one issue I would like to point at in relation to my experience as a member of the European Court of Auditors, and in showing how important it is to cooperate. And that's the issue. You mentioned the need of European citizens, companies and institutions for having an authentic interpretation. And we know the procedure, the legal procedure for preliminary rulings, etc., etc. But what we can see is that in the multi-layer legal system of Europe, but also member states, it's very hard for citizens and interested institutions to get an authentic interpretation. And in my view, it's important to make a difference between what you can call an ex post or a ex ante legal certainty. Legal certainty is essential, quintessential for not the rule of law in the books, but in daily practice you have to know what your rights are. And you are pointing rightly on an issue which is urgent in Europe and in administrative law, that you should know what the rules are. What we can, from the perspective of the European Court of Auditors, I have seen that in many cases, beneficiaries of European money were confident that they were acting in accordance with the rules. But at the end of the day, but it is not a day, it is not a month, it's at the end of years, they get a message that they were wrong. And then the Commission comes with recoveries, and everybody is making a scandal about the fact of abuse of European money. But it is abuse of law in the sense that people don't know what their rules are. So I think that for the European Ombudsman, and also for the European Court of Auditors and other institutions, it's highly important to look for remedies to make the difference between the ex ante and ex post legal certainty shorter, that you can be sure about the rights you have. And I think you rightly pointed, Mr. Ziller, on the need for an authentic, binding interpretation of European law to support legal certainty. Thank you.
It's my pleasure to hand the word to our host, the Ombudsman Emily O'Reilly.
Thank you very much indeed. I'd like to thank everybody for their contributions today. And again, thanks to Professors Hoffman and Ziller for the wonderful engaged work they've done over the last while to bring this to fruition. And we look forward to the publication of our deliberations today. It was particularly, I think, fruitful for me as an ombudsman of just 1.5 years standing for people to reflect back on the experience of the last 18 and a half years of the development of this institution. And it's given me a lot of food for thought for the years ahead. I mean, I think that this, we're at a moment of great opportunity, actually, for this particular institution for a number of reasons. That is partly because it has reached a particular status and standing within the wider administration, and that is obviously enormously helpful. Also because we are at a period where there is huge public scrutiny of the EU and its institutions, partly because of the recession and the political turmoil in a number of countries. And I suppose as we get closer to the UK referendum, that scrutiny will become even greater. And I suppose that perhaps even enhances the importance of the role of an institution such as the European Ombudsman. We also have a very dynamic Parliament, which has changed, I think, quite radically over the last while, and certainly in terms of its scrutiny of the Commission and other agencies as well. And I think if we can be seen as part of that process as well, and if we can be seen as part of that scrutiny, I think that again enhances and illuminates our role. And you also have a commission. This commission, I see from my relatively short period of time here, is quite different from the last one insofar as it has made transparency itself. It has asked people to judge it in relation to its transparency, and I think that provides another opportunity for the Ombudsman to have impact and fewer excuses for the Commission, perhaps, and indeed the Council and even the Parliament not to be as transparent as they should be. But I think I was also very, I didn't expect it to come up as much as it did today, and that is the various discussion and observations around the network. And I think a few people have reflected the fact that perhaps the piece that is missing in all of this is that link between the member states and not just this institution, but others as well. And I suppose it's caused me, even over the last few hours, to start thinking about ways in which we can engage much more with the member states and the Ombudsman. And if you remarked, or Jacques remarked there about the Petitions Committee and not realising it was a part of the network, but I think perhaps the Petitions Committee equally isn't sufficiently aware of the work of the network ombudsman, and perhaps they might, and this is something I will perhaps propose to them, think of engaging with the member state ombudsman a lot more themselves in their work and their hearings to find common cause. And equally with the initiative, I'm starting along with the colleagues in trying to find areas of mutual relevant interests where we could have parallel investigations, and I think over time you would see that having an impact in terms of bringing the member state ombudsman and the administration closer to the work that we do here, and perhaps the collective work could have a more powerful impact. So I've been given really lots of food for thought, lots of wonderful ideas, and it's been a wonderful opportunity to reflect on the development of this institution, the challenges it's faced, and the opportunities that all of the challenges that have been successfully realised have now given to me to bring it on to the next stage. So thank you all very much for that. Thank you.
I think at this point I can only thank the Ombudsman and her staff on our behalf, Pavia and mine, but also on behalf of all the authors who are gathered here. We will have a short meeting with the authors here in order to make clearer what is meant by tomorrow morning. But once again, thank you very much, and to all your staff. Thank you also to Ian Harden, who has been always very supportive in this and other occasions, and it's always a pleasure to discuss with him, also as a colleague.